SJC-12428, Commonwealth v. Kevin Graham Jr., and SJC-12433, Commonwealth v. Ellis Golden.
Ms. Lewis, good morning.
Good morning, Your Honor. Sarah Lewis on behalf of the Commonwealth. With me today is the trial prosecutor in this case, Masai King. I also would like to recognize members of the victim's family who are with us in the courtroom today. We are asking this court to reverse the motion judge's decision allowing the defendant's motion to dismiss. The dismissal in this case came just over 1 year after the defendants were arraigned for the murder of Thomas Hawkins. The judge dismissed both murder indictments on the grounds that the Rule 36 clock had run, but his understanding of Rule 36 was flawed, and that flawed understanding infected both his decision on the Commonwealth's motion to continue the case in order to secure the presence of a necessary and essential witness.
And what you say the core of the flaw is that for waiver and acquiescence to apply, the judge, looking at the tracking order, said it has to impact that presumptive trial date. Is that the error?
Yes, that is the error. The error is that he believed that waiver and acquiescence, as you just said, Justice Lowy, had to affect the presumptive trial date. And in conjunction, the error, I guess put another way, is that he looked at the presumptive trial date as the end date, and in that way turned Rule 36 on its head, and then looked retrospectively back at whether any event or acquiescence delayed that presumptive trial date, and that is not the structure of Rule 36.
I understand that if we're speaking about the excludable delay periods in B2, but Mr. King affirmatively conceded that he was not resting on any B2 excludable period of delay. So, I mean, I understand that if you have a B2 excludable period of delay, that gets excluded even if the trial date does not change, but you don't have that here.
Let me address that point in two ways. First of all, I do not agree that there was waiver in this case. The prosecutor did not fail or neglect to raise an issue. What happened was that the prosecutor was asked if he was relying on excluded time under the rule, and the prosecutor said, I'm relying on waiver and acquiescence, but also added that a chart was submitted in opposition to the defendant's motions to dismiss. And I would just point out that the Commonwealth's chart attached to Kevin Graham, the defendant Kevin Graham's opposition to the motion to dismiss, did note excluded periods under the rule, and that's at the record appendix of Kevin Graham's case in the Commonwealth's record appendix at 76 to 77.
Okay, but the judge, and again, I don't have the page number. I think the defense brief includes it in a footnote and has the colloquy, but it makes reference to B2. And that's where all the excludable delay is contained, including excludable delay with regard to a missing witness.
And I understand that, but the excludable time under B2, those enumerated specific exclusions, are one way of looking at Rule 36 exclusions, and the other way of looking at Rule 36 exclusions are acquiescence or periods of delay in which a defendant is responsible or benefited from. And those two ways of looking at the rule overlap. And here the prosecutor relied in argument on the case law exclusions as opposed to the enumerated exclusions. And therefore, it's not a waiver of those exclusions. And I would also point out that the judge is still bound by the rule, and the rule and the law allow for these two, as I said, overlapping exclusions.
So tell me, what was the acquiescence? Was it the acquiescence in the setting of a pretrial conference date for July 14th?
No, Your Honor. Under the case law, the arraignment until the pretrial conference date is included time. That does run the clock against the clock is running against the Commonwealth. But under our case law, fashioned by this court, acquiescence in individual periods of delay, then move the 12-month date under Rule 36 back effectively. And I think the problem here is that the motion judge was using this tracking order, the standing order, and using that to say that those previously scheduled dates, that a defendant can't acquiesce in those. And what the Commonwealth, I would say that the standing order does not modify Rule 36, and I would point the court to the language of the standing order, which specifically says it's intended to facilitate the timely, fair, and accurate resolution.
I understand that, but I don't understand so basically, the arraignment is June 22nd,
Yes.
and then the pretrial conference is July 14th. You're not claiming that the defendant should have said anything and said, we want that date earlier, are you?
I am, insofar as if the defendant did want that date earlier.
So, I mean, you're
And
saying that when the court sets the pretrial conference date for June 14th, and the final pretrial conference dates for July 1st of 17, and the trial for July 12th of 17, you're saying the defense counsel acquiesces when the defense counsel doesn't challenge an order which is designed to have the trial commence within the one-year period?
No, again, I think that the standing order has to be looked at separately from Rule 36. The Commonwealth is not saying, let me clarify, that by agreeing at the arraignment to these pre-scheduled dates, that's a waiver under Rule 36. That's not what the Commonwealth is saying. But under Rule 36, the defendant still has the obligation to formally and explicitly object, as this court said in Taylor, to each and every individual continuance or delay to which they disagree with.
But what was in the previous case, there were continuances of trial, and Mr. Charles says the appropriate course of action is to say, Your Honor, I object, and that would trigger the court to make a finding under B. 2F with regard to whether there's excludable delay. But I don't understand, in this case, what the defendant is supposed to object to.
I would say that the objection is based on Rule 36.
No, I know, but I mean, we're speaking about a particular attorney in a particular case, and you're saying that by failing to object to something, that constituted acquiescence in the delay. And I don't understand what you're saying when the defense counsel, you say, should have said, Your Honor, I object, and to what he or she should have objected to.
Should object to continuing delay in a case.
But what you say,
which,
tell me precisely. I mean, there has to be objection to you can't say object to continuing delay. I don't know what that means, because the judge had set a schedule of arraignment which was designed to have the case proceed on time. So tell me when you say the defense counsel should have said, Your Honor, I object to this, to something.
let me give an example. For example.
No, I want in this case.
Yes.
Tell me in this case when you say the defense counsel should have objected and what the basis of the objection should have been.
On July 14, 2016, the pretrial conference was held, and the case was then continued to September 29th for a status conference. On September 29th, the case was again continued to November 3rd for out-of-court filing of motions. During that time, I would say that the defendant, particularly Kevin Graham, did not file any motions. If there weren't any motions to be filed and there was a desire, whether it's strategic, tactical, or the defendant was ready to have that pretrial hearing, then there can be an objection. And that objection then allows the court to make a contemporaneous finding rather than what the judge in this case would see happen, which is a retrospective look at the rule. An objection would allow the court to decide whether the time would be included or excluded, and that contemporaneous objection would then allow, once the clock has, that contemporaneous objection would then either tack time onto the Rule 36 clock or not. And the Commonwealth could also make a record of whether the time should be included or excluded.
Can you refresh my memory, counsel? Was a speedy trial motion under Article 11 or the U.S. Constitution filed?
No. It was only under Rule 36. I believe in Mr. Graham's case, Rule 36C was raised, but it was not a constitutional challenge.
And just to clarify,
yes.
was this with or without prejudice, the dismissal?
The dismissal in this case on Rule 36 grounds was with prejudice, as is required, and then also there was a dismissal for want of prosecution with prejudice. And I would say...
Sorry, go ahead.
Oh, I would say on that ground that the judge did note that but for the Rule 36 violation, he would have dismissed the case for want of prosecution without prejudice. But I still think ultimately, if you read the record, it was a dismissal with prejudice. And it's how I began the argument. His view of Rule 36 really infected his view of the motion to continue.
We got a problem, though, which is our existing case law doesn't really take into account this standing order 286, right? So we have basically a change in the way the world works out there. And so we're sort of we have to sort of change the rules, don't we? I mean, we can't sort of use the old case law that didn't have these standing order in place, right?
Well, I don't necessarily think so, because the standing order, in the way it was written, did contemplate how it would align with Rule 36. The language of the standing order says that it will not supplant any existing rule of criminal procedure or statute, and that a defendant's statutory right to a speedy trial is determined by Rule 36 and not by reference for the standing order. The standing order was put in place to establish procedural guidelines.
The problem, I think, though, is that there really isn't a delay to object to, because the trial date remains the same all the time, right? I mean, I'm not sure what the trial judge did makes sense, but we do have a different universe. So the rules don't quite work under this new universe, do they?
The trial date per the standing order is a presumptive trial date. It's an aspirational date. It can move, and it exists separately in the Commonwealth's view from Rule 36, where objections to individual periods of delay can, if a judge so finds, allow the clock to run, and that time would be tacked on to the 12-month date. I'm sorry, Justice Kafter, go ahead.
No, and I don't mean to interrupt you, but I'm just trying to understand it myself. So the Chief's question, the defendant has to object to something that doesn't make a difference. I mean, it just seems odd. But at the same time, the case is tracking right till the end, and then the judge brooms a murder case. It just, neither approach seems to make much sense.
And I do think that it's uncomfortable to think at times, but I think that it doesn't seem odd to make an objection. If a defendant is ready for trial.
What would the objection? Judge, I object to this even though it's not going to make a difference on when we try the case? Is that what the defendant should? It's not a rhetorical question. It's just I'm asking what the defendant's supposed to do.
I think it could make a difference. In this case, whereas the defendants have said there were not many pretrial motions, if a case is in the posture for trial, what would happen is the defendant would alert the court to that, and the court, again, can make that finding of whether dates should move up or move back. I would say that the Commonwealth is also, would be wise to proactively ask the judge to include or exclude time when it's necessary. The parties both have obligations under the rule. Taking the standing order, the Commonwealth's obligation to set a trial date.
The Commonwealth didn't do that either, right? The defendant didn't object, and the Commonwealth didn't say we've got to add on time either, right?
No, and I think, though, to your point and the concern over how the standing order and Rule 36 can be read together, I think that there can be some advice from this court about how parties can operate under the standing order and the rule moving forward, but I don't think the standing order modifies Rule 36 in any way.
So the defense attorney would have to stand up at the earliest opportunity and say, in this case, I assert my Rule 36 speedy trial rights and do not waive any objections to delay. That would alert the Commonwealth to the fact that that they mean business, and the judge to the necessity to make findings each and every time the case comes into court.
Yes, Your Honor, and I would say that that would have to be done at each individual period in which the defendant did object. Under Taylor, there cannot be a blanket objection.
So
But
what you're
there
saying is
could
the
be, I'm sorry. Go ahead, Justice Graziano.
So what you're saying is the defense attorney can't lay in the weeds and then at the presumptive trial date say, now you effectively have 364 days counted against you.
Exactly. Rule 36 is a rule of reason. It was not designed as a trap for the Commonwealth or the defendant.
And Rule 2A actually reflects that sentiment.
Yes, Your Honor, and I.
Let me ask you a question. You may not know the answer to this. In the last 7, 8 years, do you think a murder trial in a Suffolk County has ever gone on the presumptive trial date?
I will say, as an officer of the court, I've heard of one in my mooting of this case, but it's rare, and I think that of course the parties want to expeditiously move these cases to trial in the interest of justice for both parties, but both parties are entitled to a fair trial. Yes.
One
Justice Seifer.
question before your time, well, your time is up, but many defense attorneys do in fact file a constitutional-based motion for a speedy trial at the beginning of the proceedings, and that covers them, in a sense, on the constitutional analysis. Was that correct?
Yes.
But
and
that was not an issue.
That was not done
Okay.
here, and I would say, as the appeals court recently said in Commonwealth, Polanco, I believe is the name, the defendant still has a constitutional speedy trial right in his pocket that he can use. Rule 36 is primarily a rule of case management. The standing order, if I may, has some similar values to that, although it does not modify Rule 36.
Yep, before you sit down.
Yes.
So the trial judge is pretty critical of the Commonwealth at the end about its efforts to secure the witness. How important is that to our analysis here? Because
I think
can you win even if you lose on sort of how you count because of the judge may have made a mistake on that last part?
yes, we can, and I think it's.
Why don't you articulate that? I'd like to understand that.
I think that, of course, the Commonwealth disagrees that with the motion judge's understanding of Rule 36, but to the extent this court agrees with that analysis, what should have happened is that the motion to continue should have been allowed, and the clock should have stopped at that point under Rule 36B2B. What happened here, in the Commonwealth's position, I'll briefly summarize, is that it was an abuse of discretion to deny the motion to continue, specifically after the judge had allowed the out-of-state process to issue. And allowing that out-of-state process to issue is discretionary, but it was done in this case. But having done so, the motion judge didn't give the Commonwealth sufficient time to effectuate that process, and that was an abuse of discretion. This witness was a necessary and essential witness, as the motion judge found, and was on board and cooperative and willing to testify up through April of 2017. And I think we need to look at the Commonwealth's actions once there was any indication that he might not be on board. We were in touch. We attempted to be in touch with him. Investigator was sent to Florida, and in that point there was a phone call by the witness that he would not cooperate.
We're going to have to reverse some credibility findings, right? Because the judge is finding that the delay is purposeful, right? That he had no intention of bringing the witness.
Right.
Are there cases that you can turn to that we're going to be able to do that?
Yeah, I would point this court to the appeals court opinion in Commonwealth versus Clegg, CLEGG, and I don't have the exact site in front of me, but it is cited in my brief, where there was no good reason for the judge not to believe and to not take into account the prosecutor's representations here. There was no basis to find otherwise, and there weren't credibility findings here, on the basis of an evidentiary hearing, but there were representations by the prosecutor as an officer of the court about what happened with this witness. And this was the first motion to continue on this grounds that was filed. Yes, there was a motion to continue to do some DNA testing that was denied by a different judge, but there was no basis for this judge to believe that that was an intent to also delay the trial based on our fears about our prospects at trial, as the judge in this case said. There was nothing on the record to find that. So the motion to continue here should have been allowed where, again, out-of-state process issued, yet the motion to continue was denied on the same day. And it's Commonwealth's position that that was an abuse of discretion to not allow the Commonwealth sufficient time to effectuate the process that the judge had allowed.
How much time did he allow?
He did not allow the motion to continue, but he put the case on, specifically saying this is not a continuance, but he put the case on for a week to have the Commonwealth come back in. At that point, one attempt at service had been made. I will say that 3 attempts in Florida are allowed. That's not on the record, although it's by statute in Florida, the court can take judicial notice. And after that week went by and the Commonwealth came in for the status conference, it filed another motion to continue, saying we just need more time to try to find this witness. Of course, there might be an endpoint, Your Honors, but here that was not reached.
I'm just a little bit perplexed. The judge's finding would be under B, 2B, B, a period of delay resulting from the absence or unavailability of the defendant or an essential witness. But are you saying that that matter was pressed before the trial judge, where the prosecutor simply said that I'm resting only on the issue of acquiescence? I mean, I understand there was a finding that there was not due diligence by the prosecution here. But I'm perplexed. Are you saying that was clearly erroneous and that we should look at the B2 excludable delay, even though the prosecutor told the judge I'm not resting on B2? This is the peculiar posture that I find us in.
The Commonwealth did cite to B2, B, and the exclusion, I think it's little b, the exclusion under, for the unavailability of a necessary and essential witness in its opposition, in its motion to continue, and I can give you the cite for that, if I may. It's on page 64 of the Commonwealth Record Appendix. In Kevin Graham's case, in a footnote, said, assuming this court grants the Commonwealth's motion to continue, the resulting delay will be excluded under B2B. This subsection excludes relevant delay for the unavailability of a necessary and essential witness. So that was raised by the Commonwealth. And I think it's important for this court to look at the Commonwealth's filings in this case in conjunction with the record on which the hearings were had.
And with regard to that, is that a factual finding for which we review for clearly erroneous as to whether or not there was due diligence, or is that a discretionary finding for which we review for abuse of discretion?
I believe it's a discretionary finding that's reviewed for abuse of discretion, and here I think that discretion was abused where the record showed that due diligence was exercised, and again, where the out-of-state process was issued, was signed, and insufficient time was allowed to effectuate that process. And at that point, because it was an abuse of discretion in the Commonwealth's opinion to deny that motion to continue, the time should have been excluded under the rule, and they specifically enumerated periods under the rule.
And are these defendants being held in custody?
No. They have not, and I think that the dismissal with prejudice in this case for want of prosecution and under Rule 36 is, as this court has said, is particularly a draconian measure. There is, even if the court did not abuse its discretion in denying the motion to continue, then at that point there should have been a dismissal without prejudice, or even entertaining of a bail motion, which was brought by the defendants but denied. I think there are other measures, other reasonable alternatives that could have been taken in this case and that were not taken.
So wait, you said a bail motion, but I thought you said they were not being held.
Excuse me, before the case was dismissed. I'm sorry, I misspoke
So
there.
they were, okay, I understand. They were being held before it was dismissed.
Yes, they were being held, and then it was dismissed, and they are no longer being held, is my understanding.
Okay,
Thank
you.
you, Your Honors.
Mr. Levin?
Good morning. May it please the court, Patrick Levin on behalf of Kevin Graham.
Excuse me one second. I think your clock is off. not your clock.
No,
but
no.
It says 7:20.
Yeah,
they're
we
splitting?
we were told that we only had 15 minutes between us.
I'm sorry, I didn't realize you were splitting. I'm sorry.
So
Why don't I get to a question then?
obviously, I don't have a lot of time.
Yes, rather than the wind-up, how
Okay.
about a question? Under the trial judge's ruling, are the B2 periods told prior to the expiration of this magic presumptive trial date, or does the Commonwealth start with 364 days of excludable time?
I'm sorry, I'm not sure I understand.
So, as I take it, every time there was a finding that he made, he said it doesn't matter because it didn't affect the presumptive trial date. He says a continuance has to continue that trial date.
Yes, okay.
So when we look at Rule 36 in the B2 periods of tolling, under that ruling that he made, that it doesn't matter, does that read out B2, and B2 only exists once you get to that trial date?
So the answer is no, not necessarily, because his ruling was tethered to the text of the rule requiring that the events cause periods of delay. But what I want to say is, for purposes of this case, whether the court agrees with Judge Wilkins about how that works is immaterial.
Well, I'm
because-
concerned about this because he says it didn't result in periods of delay to the trial date, to the presumptive trial date. So under that hypothetical, if the defense attorneys appropriately so filed a motion to suppress, and it was a wiretap, for instance, and it took the parties moving with due speed 2 months to litigate that motion, and it took a judge moving with deliberate speed a month to take it under advisement and decide it. That 3-month period, under the trial judge's view, doesn't count, isn't told. That's against the Commonwealth, against the Commonwealth's 1 year.
Yes, and I think that that's not really the way that this court has construed Rule 36 in the past.
But that's what the that's how the trial judge interpreted it.
I think you may be right about that, Judge.
I hope I am.
But regardless, the Commonwealth affirmatively waived any 36B2 time in the trial court. And I'm not playing gotcha here. This is not an empty formalism. And I want to echo what my sister said, that it is important that you read the Commonwealth's filings in this case because none of them cite to the provisions of Rule 36B2 that they're now relying on. The place in the chart that ADA Lewis mentioned does not cite Rule 36B2A5, which is the provision they now seek to rely on. It just says acquiescence and waiver, just like the trial prosecutor said in court. On Commonwealth's Appendix 64, in the Commonwealth's written motion to continue, that footnote does cite Rule 36B2B, but explicitly argues only that the witness is absent, not that he's unavailable, which is the argument that the Commonwealth has made for the first time in its reply brief. That claim is waived even on appeal. Now, the reason I say this isn't empty formalism is because there's no evidentiary hearing on this motion. And the judge explicitly asked the trial prosecutor if he wanted an evidentiary hearing. This is at page 226 of the Commonwealth's appendix in Mr. Graham's case, and noted that he had no evidence on personal knowledge of any of the relevant facts that would be necessary in order for him to find in the Commonwealth's favor on these motions. And asked the prosecutor if he wants a hearing, and the prosecutor says no. The only actual finding of fact that the judge makes in his order is that the trial prosecutor's explanation for why he did not seek process for the only witness that would connect these defendants to the murder is not credible, and that their real reason for not seeking process was that they were intentionally delaying the trial. And it's not true that he had no basis to disbelieve. They made a motion a month before the scheduled trial date, which had been confirmed at the pretrial hearing. Now, I know the panel is right that it's unusual for a murder case to go to trial on its original presumptive trial date, but this case was on track to go to trial on its presumptive trial date, and that date was formally assigned at the pretrial hearing, and it was confirmed. And a month before that confirmed trial date, the Commonwealth made a motion to continue that trial date for DNA testing on a piece of evidence that it had possessed for more than 12 years. Judge Wilkins' finding that they were intentionally trying to delay this trial is entitled to deference. He was capable of assessing the credibility of counsel appearing before him in his courtroom. And the appeals court specifically said in Commonwealth versus Burston that findings of this nature are entitled to deference. The fact is that if the prosecutor had just handed the judge these papers to sign at the final pretrial conference date on June 1st, the judge would have signed them and the case would never have been dismissed. That's all they had to do. They were intentionally trying to delay this trial. That's the finding.
Can you talk to me for a minute about what that means, to intentionally seek a delay or to intentionally delay a trial? What does that really mean? That they were doing it with some bad motive, that they just needed a continuance and they wanted to continue it? I don't understand intent
They
in this
didn't
court.
need a continuance if they would have just brought their witness into trial. It means they had no interest in going to trial on the confirmed scheduled trial date.
And you date that as to when? How early do you date that intention? Like, when was that intention apparent?
At least as early as May 11th, when they moved to continue the trial date. In order to conduct DNA testing on evidence that had been in the government's possession for more than a decade at that point.
But I understand the judge's finding with regard to the DNA, saying that that inevitably would result in a delay of the trial, and inferring from that that they intended that to be its purpose. But I don't recall from the record that with regard to the efforts made to bring the witness back, that this judge made the finding with regard to that. I thought the finding there was lack of due diligence.
I'm on page 8 of the motion judge's order. The Commonwealth's desire to delay the trial in this case on June 12th is the only sensible explanation for its failure to secure a timely compulsory process. The court so finds.
All right, and if we find that's a bit tough on the Commonwealth, what's the consequence?
Well, regardless whether the intentional delay aspect is a bit tough on the Commonwealth, certainly it was not an abuse of discretion for him to deny the motion to continue.
Well, I understand. I mean, that's just, going back to Justice Gaziano's question with regard to B2, assume for the moment that we do not accept the judge's legal determination that there must be a delay in the trial date, even for a excludable delay under B2 to count. Is there any excludable delay under B2 that is in the docket?
The one day, June 19th of 2017, I think, is a properly excludable delay. That's the day on which Mr. Graham filed his first motion to dismiss, and it was denied that same day.
That's it? Just one day?
That's right.
No pretrial motions filed?
The only pretrial motions that Mr. Graham filed were motions for mandatory discovery, specifically the address of the key witness in this case. And the motion judge was well within his discretion, would have been well within his discretion not to exclude that time had the Commonwealth asked him to on this ground, which they did not.
And was it ruled on? How much time between the time that motion was filed and the time it was ruled upon?
It was filed in February. I have it here. It was filed, the first motion was filed on February 16th of 2017. The Commonwealth opposed it, citing some alleged safety concerns if they were to produce the witness's address, even though there was a pre-existing protective order restricting witness addresses to only defense counsel and his investigator. So that ground for opposition is totally specious.
Okay, but apart from that, when did the judge decide it?
So the Commonwealth opposed it, and as a result of that opposition, it was called for hearing. There's a second motion filed after, so after the Commonwealth makes the opposition, there's a second motion filed for the mandatory discovery. And then the hearing eventually occurs on May 11th, and that's where it's resolved. And that's the same hearing at which the Commonwealth made the first motion to continue the trial, which was objected to by both defendants. I just want to emphasize, every time anything happened throughout the life of this case that could have delayed that scheduled trial date, the defendants did object to it.
Yeah, but before then, they sat on their hands.
They are not required to object where the case is proceeding according to established procedural rules. That's clear as
But
far back.
that's what we're going to decide now, right?
Well, you're right about that, Your Honor, but it's very clear 35 years ago in Berry, and the Commonwealth concedes, based on that language in Commonwealth versus Berry, that the time between arraignment and the first pretrial conference should count.
Right.
The reason that that time counts is because Berry says there's no reason for defense counsel to object if there's a procedural rule in place that says when things are supposed to happen. And the only procedural rule like that at the time Berry was decided was Rule 11 that said the judge should set the initial pretrial conference. And then there's Rule 13 provided 7 days after that for motion filing. And the court in Berry says, okay, well, that time from arraignment up until 7 days after the first pretrial conference counts, because it would be silly to require the defendant to object to periods of time that are required by court rule. They're not continuances, they're not delays.
Why was this required by court rule? Couldn't you have made a motion to advance the trial, to have the trial sooner?
I suppose that it would be possible to request a trial on the date of arraignment in a murder case, but it doesn't really make sense to. Let me say, the Commonwealth says that Judge Wilkins turned Rule 36 on its head. Well, Rule 36 says every defendant is entitled to be tried within 12 months. And what the Commonwealth says is, well, 12 months starts when the defendant first makes an objection to something causing a delay, essentially. That claim is roundly rejected in this court's case law, as far back as Spalding. The demand waiver rule has been rejected under Rule 36 repeatedly. It's just not true. Rule 36 means what it says, that a defendant has to be tried within 12 months.
We also have about 10 or more cases that talk about acquiescence, correct?
Yes, and every single one of those cases is an acquiescence in a continuance of a scheduled date. And I want to address Justice Kafker.
But like Dennehy's, I take Dennehy's one of those cases, right? But they're all this standing order.
No, that's what I was just about to address.
Okay.
So the standing order has been in place since 2004, and there are numerous cases that apply Rule 36 since then. And I want to call the court's attention in particular to...
Dealing with this issue where
Yes.
you've got this, where they actually address this idea where you've got this sort of aspirational trial date and nothing that moves this matters? If something doesn't move the trial date, it doesn't matter?
Well, regardless of the judge's reasoning as far as the mandatory exclusions under Rule 36b-2, certainly if something has no effect on the trial date and the defendant doesn't object to it happening, he has not acquiesced in any delay of his trial.
And I'm very interested, Mr. Levin, any cases that adopt Justice Wilkins' interpretation of that? Because
As to the acquiescence and waiver.
right, that
So-
you're basically saying, well, if you've got this aspirational trial date written down, all this acquiescence doesn't matter. It's just literally, you've read all these cases, I'm catching up to you.
So I'm going to come back and give you two cases, but I just want to focus the court's attention again on Berry and the holding that it makes no sense to require defense counsel to object when the court rules specify a timing and a procedure. And just make sure to draw the court's attention to the fact that Rule 11 and Rule 13 have been amended since Berry, and that Rule 11 now requires the judge to set the pretrial conference date and the pretrial hearing date. And I go through this in my brief, but I just want to make sure to draw the court's attention to this, that the holding in Berry applies right through 21 days after the pretrial hearing, assuming that nothing has happened to delay any of those intermediate dates. And so this is, as to your question, Justice Kafker, I have a couple cases that I want to draw the court's attention to, and they're cases that were relied upon below by the Commonwealth. Commonwealth versus Roman, which is 470 Mass 85, and Commonwealth versus Williams, 475 Mass 705, are both, they're recent cases, 2014 and 2016, and they both are, show how this waiver and acquiescence doctrine works under the standing order, because you can see in Roman that at arraignment, the judge sets all these future dates for the case, just like he's supposed to, and then the original pretrial hearing date is continued by agreement of the parties. So the time between the original pretrial hearing date and the new pretrial hearing date is now excluded, because there has been a continuance of that date with the defendant's agreement. And then the pretrial hearing is continued again and again in Roman, right up until less than a month before what originally would have been the Rule 36 deadline. And so now we're 2 weeks before the Rule 36 deadline, what the original Rule 36 deadline would have been, and the defendant agrees to a trial date that's another 6 months out. And the court says, well, obviously he has acquiesced to that also. This makes sense, where there's a date that's set and then it's moved, and the defendant doesn't object to it being moved. He is acquiesced in that delay, and Williams works exactly the same way. There's a pretrial.
Those are always easy because there's no consequence. Any cases where we've ended a murder in this kind of context?
Your Honor,
we've got
capital
someone,
defendants under the rule are also entitled to be tried within 12 months.
right, I know, but we're talking about the judge not allowing basically a couple of day delay, really. This is a case where it was actually going to be tried for the first time in the Commonwealth's history on time, and the judge doesn't let it extend a couple of days because he concludes that the prosecution has not reacted quickly enough in terms of getting this witness from Florida. It seems extraordinary to end a murder case in this context when it's a couple of days past that deadline, which was an aspirational deadline. But again,
No,
if
no,
the
it's
cases,
not an aspirational deadline.
But if the cases say, I'm very interested, if you've got cases like this, where we've decided that murders can't proceed in this context, I absolutely want to read those.
Your Honor, Rule 36 applies to murder cases, and
I
it says they
understand it
have to be tried
applies.
within 12 months. It's not an aspirational deadline. It's a deadline that's set by a court rule.
I get it's set by a court rule, but it's also a case in which we're reading out a lot of our prior case law where if you acquiesce to a delay, and I understand—
There was no delay.
I understand that the way Judge Wilkins interpreted the standing order has some appeal there, but it seems like we've not wrestled with this problem before, and we need to wrestle with it directly, which is that the structure of the way this works now is a little different. But you're right, the standing order's been in place in a while, but we've never sort of come to terms with this conflict before.
Well, you're right that there hasn't been a case before that has proceeded on track without any delays.
Mm-hmm.
And I don't see why a case that proceeds on track without any delays, that this court's conclusion then is, well, obviously the defendant acquiesced in a delay, and he can be held for 2 years pending trial.
You may be very well right that the defendant didn't acquiesce, although we have a bunch of cases that say even futile objections are supposed to be made, right?
Futile objections to a continuance of a scheduled trial date, which no date was ever continued in this case.
No, the language from those cases, again, correct me, because you're very good at this. Those cases don't make that express point. They just say futile objections need to be made. They don't make the back end point, right? Or do they?
No, Your Honor. In Dennehy, the only objections at issue there are court congestion continuances of scheduled trials. And so the court cites back to cases that say when a scheduled trial date passes without an objection, we assume that the defendant has acquiesced to that delay of his scheduled trial date.
Do those cases, and again, we're going to go back and read them, do they loop it in as nicely as you and Judge Wilkins just did? Or do they just say you have to object to things that create delay more generally?
Yes, this is what I'm getting at, is this is what they say. You have to object to delays. There are no delays in this case. The judge, there's a scheduled pretrial conference, right? And that occurs on schedule. There's a scheduled pretrial hearing, and that occurs on schedule. Those scheduled dates were set not pursuant just to the standing order, but pursuant to Rule 11 of the Rules of Criminal Procedure. There's nothing for the defendant to object to. His case isn't being delayed, it's on track.
I think what might be, I understand your argument, but I think what might be missed in your argument that we might be missing, quite frankly, is that the pretrial conference under the tracking order is different than the pretrial hearing. And the pretrial hearing is presumptively halfway through the track.
Right.
And the pretrial hearing moves depending on what's going on in the trial. Discovery not being complied with as yet. And I think that you're just sort of assuming that part of the argument that we're getting.
I think you're just right about that. And so that's what happened in Commonwealth versus Roman, and that's what happened in Commonwealth versus Williams, and that's what happens in most Superior Court cases.
Right.
Is the scheduled pretrial hearing date moves. And when it does, if the defendant doesn't object to that, he's acquiescing in a delay. But when it doesn't move, there's nothing for him to object to. There's no delay.
That's just a matter of understanding the difference between the pretrial conference and the
Right,
pretrial
yes.
hearing in the context of the tracking order.
Yes, I'm sorry if that wasn't clear. But I just want to one more time go back to this point about the judge's discretion. I don't see how the judge can have abused his discretion by denying a continuance based on a motion that wasn't supported by an affidavit on personal knowledge. When he asked the prosecutor if he wanted an evidentiary hearing, and the prosecutor said no.
Well, what do we do with this? I mean, and this probably nothing, because it's probably on the record. But the craft in this situation is not to bring a witness who's equivocating into a hearing in Florida to see if they're material and necessary. You bring the trooper down there, you try and see if you can get them to cooperate. It makes all the sense in the world as far as the craft goes that's underneath this, not to do what Judge Wilkins is saying, why didn't you do that? That's sort of a real-world situation, and I suppose that's all beyond the record, and there's nothing we can consider in that regard.
I'm not sure about that. What I can say is if the Commonwealth wanted facts considered about what was happening down in Florida, they should have at least put an affidavit in the record on personal knowledge about what those facts are.
If I can go back to an earlier question with regard to B2, I see that there was a motion to dismiss filed on April 25th. I don't see any ruling on it.
There never was a ruling on it. There never was a hearing or a ruling on it. The judge mentions it in his order. It's the motion to dismiss the ancillary charges on statute of limitations grounds.
And
And the Commonwealth concedes that that motion is meritorious. The statute had run by the time the indictment was returned. Although they never have they never did null pros those other charges, but the statute of limitations had run on those.
and
Because the crime happened in 2004, and the indictment was returned in 2016.
and was there a hearing on it?
No, there's never a hearing on it.
So it was filed, but there was no hearing.
No hearing was requested or held, and it had never been ruled upon.
And your view is that under B2,
Well, B2 only provides to exclude time based on hearings on pretrial motions.
so based on the hearing until the time the judge decides it?
Well, no. So yes, B2 provides, B2A5 provides for excluding time. The time, what the reporter's notes say is from when the hearing is requested or scheduled up through the end of the hearing. And then there's a separate provision that excludes up to 30 days in order for the motion to be decided. But again, that's all waived by the Commonwealth, explicitly waived. And I want to emphasize again that this is not empty formalism, this waiver point. If some of these legal arguments had been made to the judge and he'd made a different decision on the motion or even held a hearing, like knowing that some of these facts down in Florida perhaps might be dispositive on this motion based on Rule 36B2B, he could have held a hearing and made different findings, and there could have been a different outcome on this motion, and these defendants could have had their trial by now. This is a situation where if the court were to entertain arguments to reverse the trial judge that were not made below, and in one case not made until the reply brief in this court, that would prejudice these defendants.
Okay, thank you.
Thank you very much, Your Honor.
Ms. Bolgen, we've not forgotten you.
Ms. Bolgen, just want to compliment you on your detective work on the 16L letter and figuring out the reporter's notes to Rule 36. That was good work.
Thank you, Judge. It certainly was not my intention to track down the actual reporter to answer the question, but it worked out that the assistant reporter works upstairs and sat down with me and explained exactly what happened in this situation so that the phone call, I understand, from social law to Lexis was described as awkward. In light of the time, I'd just like to make a couple very quick points. There were 2 motion judges that did not buy the Commonwealth's argument for why they didn't timely summons Mr. Garcia. It was Judge Sanders on May 11th that basically looked at the Commonwealth and said, you know, I don't think your prep is very good, and denied a continuance. And then it was Judge Wilkins who denied the continuance on the actual issue. But the finding that I'd like to draw the court's attention to is on page 26 of the motion judge's findings. It says, given the Commonwealth's 2 motions to continue and failure to secure DNA analysis and summon a key witness, the likely explanation is that the Commonwealth did not want to go to trial on June 12th, even with Mr. Garcia, when it had a weak case that would not get worse with time. So the Commonwealth is asking this court for extraordinary relief. They're asking this court to take a rule that heretofore had quantified a defendant's constitutional right to a speedy trial at 1 year and essentially turn it into 2 years.
Can I ask you a big picture about Rule 36? Because, of course, the tracking order has different tracks for the complexity of cases. So we're at the last track because it's a homicide case, a C-track case. Owing to that complexity, the time it takes into account, as I understand it, how long it would take the defense and the Commonwealth to build a case, to prepare for trial. Within the rule, there are these excludable periods, these B2 periods, that toll Rule 36, correct?
There are, Judge, and thank you for bringing that up, because that's where we differ.
Right.
Golden and Graham are pretty much the same on all fours in every sense, except that Mr. Golden filed a motion to dismiss on January 11th, and it was decided on January 13th.
So these B2 periods are things that would take either the defense attorney or the prosecutor away from trial preparation. For instance, a delay resulting from mental health examinations, or delay resulting from hearings on pretrial motions or motions under advisement. So we told Rule 36 because we realized that busy lawyers are going to be taken away from that 1 year that they need for trial prep to get ready, correct?
But should you? Should you toll automatically in a case like this, granted a very unusual case, but a case like this where all the standing orders went by there was no delay, because the issue this issue came up in Taylor in 2014 for this court, where you had some fairness concerns about holding a defendant to B2 exclusions for discovery.
And what we said in Taylor was you have to raise your hand and file a motion to compel.
And the question that is this case is, how does this court, as Justice Kafker brought up, wish to harmonize the standing order, which is how cases proceed in the Superior Court, with Rule 36?
But if we adopt the Wilkins view, all that B2 excludable time is out the window until after the presumptive trial date.
The answer to that question, Judge, is if the trial date is held as scheduled, then whatever might have happened with motions to suppress, motions to dismiss, so on and so
Or
forth,
a psychiatric examination
or
for
a
6
psychiatric
months.
examination wouldn't have delayed the trial. So under the very limited rule of this case, where you had the trial show up on the day, I would agree with you. But the thing this court needs to realize is that this is a very unusual case. This is a case where it's squarely presented to this court. How do we want to harmonize the standing order with Rule 36?
I absolutely agree with you on that.
1 year, 2 year, no question. And so with regard to the B2 exclusions, I would ask this court to go back to Taylor. And what Taylor essentially says is, there might be fairness reasons. It might not make sense to automatically exclude B2 time. And this may be one of those situations because, query, Mr. Golden has these January 11th to 13th, these 3 days. Mr. Graham doesn't. The defendants are absolutely the same in every respect. So if this court makes the extraordinary judgment, well, Mr. Graham's case gets dismissed, but Mr. Golden doesn't because of these 3 days, then I would ask this court to go back to Taylor and think about, is that fair? Does that make any sense at all when those 3 days had no impact at all on the trial date? And that's what Judge Wilkins, I think, is trying to get this court's answer on, is in the Superior Court, you have the standing order. You have these 2 defendants, maybe the first ones ever, I don't know, that went ahead and did it exactly by the book. Their trial shows up, and then all of this stuff happens with regard to the witness. What happens? Do they lose their right to a speedy trial? Do they have to sit incarcerated for longer? And that's why I made my constitutional arguments. I made my due process arguments. I made my equal protection arguments. Because at that point, fairness has to rule. Whether or not this court decides to reach constitutional due process concerns or not, fairness underlies due process, whether or not constitutional provisions are invoked. And that's what I'm asking this court to think about when you're looking at what Judge Wilkins tried to do. He tried to do the fair thing.
We have many, many cases where we've gone through the Rule 36B2 calculations. Have any of them spoken about the impact of those excludable delay periods on the ultimate trial date?
No, there's not one case that any of the esteemed lawyers sitting here has been able to find where the original trial date was scheduled within the year period and it never moved.
But there are
This
dates
is
in
the
which it was
first one.
scheduled afterwards, but the calculation in terms of was there a speedy trial violation is generally focused on going to the docket and saying a motion was filed, and a hearing was held, and the judge issued a ruling, and that's 24 days, and
Those
then
cases-
adding those up.
Absolutely, those are a dime a dozen. That is not this case. This case squarely presents the issue. What do you mean by the word delay?
But we've had lots of Rule 36 cases post-standing order.
Let me say there is not a published case that we can find or that Judge Wilkins could find that addresses the situation where the trial date was scheduled and the trial date showed up and there was not a continuance of that date. That's the posture that this case is in. That makes it very unusual. So what this court decides to do with this particular case probably won't apply to a whole lot of other defendants.
But I'm confused a little bit by that. So if we've got tons of cases post-standing order,
Yes.
and we have lots of cases, just as the chief asked, where we just look at the docket and subtract the time.
Yes.
Isn't that inconsistent with what Judge Wilkins did? Because, okay, why not?
Because this case is the one case where the trial date was scheduled at the time of arraignment as June 12, 2017. June 12, 2017 showed up, defendants answered ready.
We
If-
don't-
if
we
any
don't
of the
know that-
parties-
Do we know in those other cases whether the trial date,
Justice Caffer, what I can tell you is that every speedy trial case I went into the facts and attempted to determine exactly your question.
No,
Was there a
you've all
trial date
done
that was-
painstaking work. There's no complaints about the briefing here. It's well done, so.
Thank you, Judge.
Well, let me ask you about the comment you make that this case won't affect any other case. If you are a defense attorney, Mr. Levin's a defense attorney who represents someone presently charged with murder in any county, and their case is 3 years old, and there's a lot of those people around, unfortunately, but that's the case. If we adopt the trial judge's view of the world where nothing matters until after the presumptive trial date, we've said to every defense attorney, you've got 364 days in the bank for speedy trial. All you need is a few more days, and you got a dismissal with prejudice.
You've also said to all the prosecutors, you know, we really mean it when we say it should be a trial within a year. Yes? So what's sauce for the goose? What the prosecutor then would have to do is say, well, is this motion to suppress a 3-day problem that won't affect my trial preparation? All right, no worries. Is this motion to suppress a 3-month effort that, boy, all of my resources are going to be in it and I'm not going to be preparing for trial? Well, if so, then we're going to have the fight about excludable time. So the issue...
But the excludable time fight would be meaningless at that point. You'd have to fight it after it came and went, wouldn't you?
If the trial date ultimately was delayed. So the issue here, Your Honors, is if a trial date is never delayed, ever, that's when this case comes into play. But apparently that's unusual, that as Justice Lowy pointed out at various pretrial hearings and conferences, things get moved, things get scheduled differently.
Now,
This case is
you've been
different.
talking about fairness, and I appreciate that, but is there, to not some degree, I'm still troubled a bit by the finding that this is an intentional attempt to delay a trial, and isn't there a component of, I mean, there's an intent in terms of we want to get our witness in, and so we do want a later trial date, but it's not an intent to delay for a nefarious reason. And isn't there some degree of fairness that has to be applied to the Commonwealth and the victims in the case?
Absolutely, Judge.
And so how does that factor into this?
First of all, what the trial judge did here was not say, trial date, June 12th comes, you don't have your witness, too bad for you. What the Commonwealth did on June 12th, or I believe on the 9th, is they asked for 2 weeks. Give us 2 weeks, Judge. We can come up with our witness in 2 weeks. And eventually, although the judge up and down said the trial wasn't continued, and it wasn't, he didn't start the dismissal proceedings until June 22nd when he had the hearing on the motion to dismiss. And he didn't dismiss the case until June 27th. So that was 2 weeks. The Commonwealth asked until the 26th of June to get their witness. And then they didn't even summons their witness until after court ended on the trial date. So there's many former Superior Court judges that I'm speaking to. Judge Wilkins, I think, is trying to control his courtroom. He is trying to say to the Commonwealth, listen, this is the first-degree murder case. These people have been incarcerated. You know, give me something. And there wasn't anything. And that's why this case is here before you.
All right, thank you. We'll take our morning break.
Thank you.